Good afternoon, folks. This is TJ. This is the UR Law Premium Members webinar conference call for August 20th, 2019. Welcome you all for being here. As you know, we'd like to start off our webinar with a brief prayer for those who wish to join in. So feel free to prepare as you choose. In the name of the Father, Son, and the Holy Spirit. Lord, thank you for all your blessings. Thank you for all the knowledge and wisdom you've given us, and really, frankly, for all the wisdom and knowledge you've given all of this group together, because we know that when we're together, we do form a much more powerful force in your name. And so I just thank you for that and appreciate your being with us and guiding us. Even though sometimes it feels painful, we know that you're always pushing us forward. So for those challenges, I thank you. In Jesus' name we pray. Amen. Just remind everybody about our legal disclaimers. We are not here to give you legal advice. We do not provide emergency legal services, in spite of the number of times I get asked that every day. Just can't do it. You know, it's not physically possible for one person to keep track of all the details of all the cases in all the states and all the counties and all the cities. I don't know any of those laws. I look stuff up, just like you have to. You got to do the work. And so just keep that in mind. We're not here to give legal or tax advice. We might cross into the realm of talking about those things, but also now you're free to do it together thanks to our new forum. You can also get in there and have some discussions, as well as our Telegram group, as well as, well, those are the main forums for you to be able to communicate with one another. Excuse me. So always keep that in mind. Now, before anybody gets in the queue by pressing *6 to get into the queue for questions, remember, I don't want anybody in the queue yet. All I want is people in there who can start off with some kind of a success story. We will not be taking questions until we get through the success stories. So if you're in the queue, you've queued yourself in, take yourself out until we get to that point, because it kind of depends on time. We will have time, but we kind of have an order of things. We're going to do things today. And number one is when we get to questions, the first ones in the queue must be success stories. Okay? And then I do have sort of a little lesson I want to get into today, because sometimes, I have to pray and think about, what's going on? What kind of questions am I getting in general? Because I cannot answer all the questions that everyone has, but I try to do my best. I do email people back as long as you keep it concise and to the point. I'm finding a lot of people having a particular challenge. So I'm going to get into that here in a minute. But again, I want to remind you, the reason also that I stress everyone own the How to Win in Court Without a Lawyer course will be supported by what we're going to talk about tonight. But it's just knowing how to handle procedures. Again, a common question I get is, well, what do I do next? Well, again, I'm beginning to give you legal advice. I'm telling you what to do next all the time. But if you have a program, we give ideas that we give. We're kind of an idea source. That course is an optional course, totally optional, but it's the cheapest money you'll ever spend to save yourself attorney time down the road. Less than the cost of 1 hour with an attorney, you'll know how to do what attorneys do. It's not that difficult if you take that course. So it's always recommended. Yes, we want to stay out of court, but we also have to realize we're always in court anyway. Everything you say and do will be used against you. Ever heard of that? You're in court all the time. So you've got to understand that if you get brought to that court situation, how it works. And that's like trying to play a game of chess and not having the faintest idea that it's not checkers. It's just crazy to go there and do that. You're going to lose, and most people do. So it gives you the foundations of procedures and things like that, plus a lot of ideas about what to do next in many situations. So just keep that in mind. It's really important that you know procedures. We try to give you what we can, but to me it's more of a comprehensive. I mean, there's literally a certificate you can get by taking that course that you should all set the goal to get. Complete the certificate, pass the test. It'll help you immensely in applying a lot of the ideas that we give you. Okay? We try to give you some of the unusual, creative approaches to doing things, but still you have to go through the process yourself. I can't be there. Nobody else can be there for you. The whole point of this entire program is to lift you up and enlighten you as to what you can do. You are the force. I mean, what's falling apart in our country, you want to blame Washington and the Congress and this and that and the other thing? Start blaming yourself. Accept responsibility. That's what this call is going to be about. You know, if you kind of got yourself into a situation, maybe because you got a problem with child support, well, look back. Did you get a state license bringing them into your life? You didn't have to. If you had a traffic problem and they pulled you over and they, showed them a driver's license, you just kind of told them you want to play in their pool. You want to play in their pond. If you want to work for McDonald's Corporation, go sign up to work for McDonald's Corporation, and you will be subject to their rules. So anytime you get a license, a permit, a registration, all those things, and I'm not saying not to get those things. I'm saying if you do, just know you've got some rules to work with. Okay? And you can still win, but you're going to have different challenges than someone who didn't do that. So, for example, if you got married with a private service with some witnesses and you put it in a Bible or you created a contract that you can record publicly, then that's your contract. Whereas when you go to the state and say, hey, well, instead of filling out my own one-page contract for marriage, I'll get one from the state. And then see how much they get involved in your life. You asked for it. Don't blame them when you asked for a benefit. Okay? So I think what I'm hearing a lot from people lately is there's anger, there's anxiousness, there's fear, all of which are normal. But you know how you overcome it? I'm going to show you a way to overcome it tonight. So I hope you're paying close attention. This is not to get into any one specific kind of legal issue or give you one template for this, like give me a template so that when I got pulled over, I was going 95 in a 35. I happened to be, have this in my car and 2 kids. So I need a template that has all that information in it. I mean, come on. You guys got to think your way through this. You have to start at the beginning and address the problem yourselves. Okay? We're here to bring you, we're kind of to teach you how to drink. We'll lead you to water and teach you how to drink, not do the drinking for you. Nobody can do that for you. And when it comes to law, if you don't have basic understandings of law, and I mean talking just basic biblical law, even, you don't have a chance. And I don't care whether you believe in the Bible or not, our legal system is built upon those principles, whether you like it or not, and you're in it. Now, you want to go live in a cave and kill water buffalo for dinner and, don't talk to anybody and never ever say anything to anybody or cross anybody's street or go near on somebody's property or go to a restaurant or buy gas or buy groceries. If you want to do all those things, you don't want to do any of those things, you can avoid contracting. But if you're doing any of those things, you're in contracts all the time. You're in negotiation for contracts all the time. So anyway, that's kind of our basic subject for that. I don't want to get ahead of myself. So again, if you're in the queue for a question, make sure you're there for a success story. We'll get to you in a little bit. But let me get over to this because I did make some notes. If you see some typos, it's because I just really finally got this finished right before the call, so I didn't have time to proof too much. But I think you'll get the general idea. So tonight's subject is being a creditor, and being a, I'm sorry, there you go, there's my first typo. Being a creditor and, start over again. Tonight's subject is being a creditor and defending your remittance. Now, what does that mean? Being a creditor versus being a debtor is what we are called to do. And we're in trouble because of a basic understanding that we don't have as to who we are. We're commanded, and this is going to get a little bit into some Bible teaching. It's not to teach you religion. It is to teach you the rules of the game. Okay? So I'm not making an excuse. I have no problem talking about that, but I've always seen the Bible, have for a long time, as a guide, as a tool to teach us how to live our life. It's not just about not sinning and not going to heaven. It's about how to live your life and how to use the law to your advantage instead of to your disadvantage. We perish, in the Bible it says, we perish for a lack of knowledge. That's it. Woe unto you lawyers for taking away the keys of knowledge. That's the only time Jesus ever kind of criticized somebody. Because we depend on them to take care of it instead of our own knowledge. Those two verses together tell you a lot. If you have problems, it's because of your lack of knowledge and the way you've handled it, the way you've dealt with it. So tonight I want to talk about when in the Bible also talks about being the lender, not the borrower, being the head, not the tail. I don't have all the sightings here. I'm just telling you these are lessons you can get out of the Bible. But primarily what that means is being the creditor, not the debtor. Okay? And if you can get this little exercise down, and we're going to have a little bit of homework for you for next week. If you can get this exercise down, next time you have to deal with the law in any way, you're going to do it differently. I guarantee you. And you're going to find out that this stuff works. It may not work the first time, the second time, but if you stay with it the third time, usually it works. So you have to be patient. So know that these are the rules of the game for what we're going to talk about here, okay? So let's start with, and I'm using Matthew 5:25 from the King James Version. Now, the King James Version is the one that is closest to the actual written law. That's why we use it. There are many other versions, but some of these new modern versions that try to give you simplistic language actually really altered the meaning of the terms. So King James is the closest to the original text. As our law, it relates to it. I'm not debating what Bible's right. I'm just telling you this is the one from which a lot of this is written. Okay? Matthew 5:25. Agree with thine enemy, with thine adversary quickly, whilst thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence, till thou hast paid the uttermost farthing. Okay, what is that essentially saying, legally speaking? It means agree or conditionally agree with your adversary quickly. Don't sit there on the side of the road and argue and tell them you're a traveler and I'm a this and I'm a that. Debtors make statements, creditors agree and make deals from the beginning. Now, that doesn't mean you're going to make a deal with the devil. It means you're setting conditions, okay? So, for example, if you're pulled over, you might be saying, well, can we search the car? And you say, well, sure, you can search the car upon the condition that you produce a warrant that's also written in the correct name and correct syntax, structure, parse, grammar, and so forth. If you can give me that, sure, you can search the car. But if you can't, well, then I guess we don't have an agreement to do so. That changes the tone of the conversation completely, and it puts conditions out there. Why are we saying that kind of stuff right up front? Because you're establishing good faith, and you're also establishing conditions that are reasonable, but they should use your correct name, right? Not the fictional name, but a real name. They should use the correct sentence structure, parse, syntax, grammar, common communications that you can understand. That's all you're saying. And if you can do that, produce a warrant like that, sure, then you can search. And if you're kind and you're straightforward like that and you're asking really non-adversarial questions, and you're agreeing, you are agreeing with a condition, that's called conditional acceptance, you watch what happens. And even if they take you and pull you in, and you keep doing that every time they ask you a question, you kind of throw a little condition in there that you agree with. Keep agreeing with them. You watch what happens. You may not get delivered to the judge or the officer and cast into prison, jail. If you do that, but if you don't do this, thou shalt by no means come out thence till thou hast paid the uttermost farthing. Paid, the uttermost farthing. Now, please understand, it's always about a transaction. Going to jail is a transaction. Being pulled over. Your court starts not when you get to the judge. See, everybody thinks it's when I get to the court. That's a huge mistake to make. It starts when the lights come on, when there's a knock at the door, when somebody asks you a question. It starts right then. The recording starts. Everything you say and do can and will be used against you. They'll tell you the truth. So instead of being a victim to that, why don't you become the creditor, be the head, not the tail, be the lender, not the borrower, and make your conditional agreement right there. Now, maybe you were speeding. So you know what? Sometimes you have to accept some responsibility for that. Maybe you're not paying your child support, and you frankly should. Maybe you should accept some responsibility for that, but always come with your hat in hand to the degree that you can actually negotiate. Everything is always a negotiation. Going to court, when they speak to you, they yell at you. They say, the judge made me do this, the judge made me do that. I guarantee you he was actually making you offers. But you don't know how to recognize an offer when you hear it. Because you're fighting, you're denying. And you know what? Maybe you need to pay the uttermost farthing before they're going to let you go. Maybe they need to kind of teach you something. Hopefully it's not long term. This is why you've got to memorize this. Okay, so one of the objectives is that everybody memorizes this verse. But also get it. What is it saying? This is telling you how to deal with the law. Okay? It also gets into Matthew 18, verses 15 through 16, 17, and 18. Also covers this as well. Matthew's full of great legal guidance. How to live, how to manage yourself, and how to manage your legal affairs even. It may not make sense to you right now, but trust me when I tell you, this has been around way longer than you and I. This has been around, these rules probably been around for thousands of years, even before Matthew spoke them. But you're there. These are universal. It's like gravity. This stuff works. And if you can put in context whatever's going on in your life, maybe it's a mortgage lender coming after you and suing you. Maybe you need to just try to, because is it worth losing your house over trying to make a legal point? We all know that maybe there's a fraud and there's a phony thing going on. I accept it. But you know what? You also got into it. So maybe you need to try to work something out. My first remedy for a mortgage, by the way, everybody, on a mortgage particularly, not certain other unsecured debts, a little differently, but on a mortgage is figure out how to settle the payments and actually pay it off early and just get rid of it as quickly as you can. Your statistical chances of getting it in your hands are way better that way than fighting them in court, statistically speaking. It's not easy to fight them because you're always fighting. Okay? And so it's very, very difficult to do. I'm not saying you not to do it, and just weigh the odds. Maybe you should agree and try to settle and then work out a payment plan. But not only pay it off, but pay it off early. Get rid of it. That's what we used to teach back in the early 2000s when I had another program that we did. And it was only focused on just how to accelerate the debt. And it's peaceful. There's no harm in it. It's not that hard to do. A couple of extra payments a year, and you cut it in half. It's not that hard to do once you beat the compound interest curve. I'm just saying there are different ways to handle some of these things. Sometimes you've got a big, huge IRS bill or something that's coming after you. Look, I've tried to fight it, and they've made it very difficult for me. They do for most people. And you might be right. The law actually supports that maybe you didn't even have taxable income. That might be true. But at some point, you might have to work something out. And then going forward, there are things you can do to stay out of it. Just don't get yourself into the game. Okay? So sometimes you can't win every battle. One of my best mentors taught me, he says, every game is winnable if you know what game you're playing. A lot of cases are not a winning case because you're not playing the winning game. You're playing the losing game. You've already got yourself into something. But you have to try to settle your way out. But then going forward, stop getting yourself into these things. So anyway, that's a great lesson from Matthew 5:25. And let's read 5:38. Ye have heard that it hath been said, an eye for an eye and a tooth for a tooth. Now, that's what we all tend to try to do, right? But I say unto you, by the way, this is always Jesus speaking here. You need to know that ye resist not evil, but whoever shall smite thee on thy right cheek, turn to him the other also. It's saying, hey, if you get yourself into the situation and they smack you, just take it, calm down, and then stay on track. So if any man will sue thee at the law and take away thy coat, let them have thy cloak also. In other words, don't just give him your coat, give him something extra. I know that sounds strange, but these are directions here. And whoever shall compel thee to go a mile, go with him twain. Give to him that asketh thee, and from him that would borrow of thee, turn not thou away. That means help your brother. Don't be stingy. Ye have heard that it hath been said, thou shalt love thy neighbor and hate thine enemy. But I say unto you, love your enemies, bless them that curse you. That's right. Do good to them that hate you, and pray for them which disrespectfully use you and persecute you. And boy, folks, that is a hard thing to do, isn't it? But when you do it, you watch what happens in your life. That ye may be the children of our Father which is in heaven. And he maketh the sun to rise in the evil and on the good, and the setteth rain on the just and on the unjust. Let him settle it. Don't you try to fix all your problems in those situations. For if ye love them which love you, that reward have ye. Do not even the publicans, by the way, a publican's a taxpayer, do not even the publicans the same? You know what, you got to love them too. And if ye salute your brethren only, what do you more than others? Do not even the publicans, the tax collectors, so? Be ye therefore perfect, even as your Father which is in heaven is perfect. So in other words, don't engage in these battles. Sometimes you got to just take it a little bit, move on, accept something, and this is really a hard key for a lot of people. But when you get it, and those who have done it will be able to tell me, yes, it works. I assure you. It may not seem like it's working at first. Sometimes you don't know what's going on, as my friend Jack Smith used to say. But it's going on. As long as you're staying on focus, staying on point. Sometimes you have to do it once, twice, or even 3 times to see it actually work. Okay? So whatever you're doing, don't be I've saw some emails from people this week where I could just see they're trying 10 different things. They're fighting. I'm not going to. They're going to court and they don't have no idea what to do. They have no idea what to do. Sometimes I say, look, just simplify it. Why are you there? Did you get yourself into something? Why don't you accept it and give them a condition? By the way, when we talk about the correct sentence structure, syntax, parse, response, that's what we're doing. We're accepting and giving conditions. That's all it is. So keep that in mind. So being the creditor. Now what is that? What does that look like? So first rule is don't argue. Be the creditor, not the arguing debtor. Remember, if you're acting like a debtor, you are a debtor. And ladies and gentlemen, a lot of people don't like to hear this, but there are no papers on the planet that are going to prove you're a creditor. Now, I don't care if you're an SPC, you filed a UCC1, you wrote a bunch of affidavits, all that. Your outward actions will be judged far greater than just documents. Documents might set up a foundation for an argument, but you're probably going to have to go to court and argue it. So if you're going to put documents in, be prepared to understand what it is you're actually there to do. And you might have to do it verbally. And if you're not ready to stand up and show that you're a creditor, as opposed to just say you're a creditor, then you're not a creditor. Let me say that again. If you're not prepared to show up and show them what a creditor does and acts like, you're just depending on a piece of paper, then you're not a creditor. Now that's something a lot of people don't like to hear. They always ask me, give me the magic template, the one template that's this most bizarre, weird offshoot scenario. Give me a template for that. Well, number one, that doesn't work. Number two, how could I write a template for every scenario? And number three, it misses the point. What is the basic outline actually trying to show you what to do? We're trying not to just argue. We're trying to settle. Always offering to settle. Even if you think you've been wronged. Right out of Matthew 5:25 and 5:38. Just let that, take some responsibility for being where you're at to a certain degree, and just see what you can work out. Now, I don't mean always just because the prosecutor offered you a settlement. You can do more than that. But as long as you're doing in a way which you are accepting, conditionally accepting, or asking questions carefully, doing one of those three things at all times. And I'm talking from the second you're handcuffed to the second you're put into jail, from the second you're offered food. It's just every step of the way. You want to practice this in every word and every utterance out of your mouth. Okay? If they say, hey, we'll let you out in the morning and with no charges, well, would you fight them over that? If you can just kind of get out? That's an acceptance, right? Or maybe you say, well, they pull you over, like I said earlier. They pull you over and they say, well, can we search your car? He says, well, I could let you search my car if you produce a warrant, and that warrant is produced in the proper name and the correct sentence structure, syntax, parse, grammar. If you can just give me that, I'll be happy to do it. Or if you want to sue me, you say, well, I'll accept your suit as long as you can correctly identify me by the correct name and use the correct sentence structure, syntax, parse, grammar, give me a clear set of definitions and so forth. That's what our syntax response does. It's nothing more complicated than that. I mean, you can screw it up and still make that point. Everybody's worried about it being perfect all the time. Sometimes you only have to shoot one arrow to kill a deer. Okay, so just keep simple what you're trying to do. And if you've got to ask questions, ask very careful questions, not so much questions to try to embarrass them, but simply questions that kind of get them back to your point of, hey, well, I'd be happy to accept if is a conditional acceptance. Okay, you do that 2 or 3 times during an arrest or incarceration. You watch how much faster you get out than fighting. You people, you're all corrupt. You're the United States Corporation, and you're the IRS, or you're just all about the dirty cops. Hey, most of these people are just people too. They got a job to do. Now I know it's true. The Nazis at Nuremberg also said we were just doing our job, but you still have to, even like the Bible says, you still have to turn the other cheek, and just keep. It's who you are. It's how you act that matters, not who they are in this scenario. They might be violating the rules, and you can bring that up later. But right now, and of course build your record if they are, but for now, accept. And say, well, I accept that, provided that you just didn't break the rules giving it to me. See? So actually what I want to do is I'm going to have you in the chat room. I want you to type in. Don't do a bunch of chatting and chit-chatting and talking and, hey, hello, how are you, please. Just do what I'm asking you to do so we can go through this. I want you to type in the window a conditional acceptance of something, for whatever scenario it is you might be dealing with. Maybe they're going to, and remember, an offer doesn't say, oh, we hereby offer you this. It's an offer. It might be just something the judge says or a cop says. Roll down your window. Take that gum out of your mouth. Sit down. Stand up. I mean, you don't want to get crazy with that, but just, be careful. When they're giving you orders, they're actually giving you an order like almost in a restaurant. It's an offer. Always think of it that way. Okay? Remember, remain the borrower, become the lender, not the borrower. Okay? Let them be the borrower. But what they're trying to do, when we talk about flipping the switch in the trust, expressing the trust, they're trying to switch it around and make you the borrower, the debtor, the defendant, not the lender. But we are the lender. The people formed our Constitution. And it's built on these foundations. The Bible is the background of it, then the Constitution supports it. They are the debtors. They work for us. We're the lender. They're the borrower. But as soon as you start arguing, you just become the defendant, the debtor, and so on and so forth. And if you argue, you're denying an offer. So, no way, you're not going to do that to me. Well, then, guess what? They have a duty to treat you like a debtor. And then you can't question why it is. Accept responsibility for that. And you watch what happens. It's against our general nature. You look at what's going on back east in Washington. People are arguing all the time, and no matter what somebody says, somebody's slandering somebody else. It's a bunch of debtors back there. They're not acting like creditors. We need to rise above that. We want to fix this system. More of us need to do this, not wait for them to do something. But when you argue or deny, you're putting the burden of proof on yourself. Stop doing that. You're innocent until proven guilty. They have it written into their law. You're a creditor until proven you're not. And only you can prove you're not. You're innocent till proven guilty. You're a creditor until you stop acting like one. It's your actions that are your key. So, and another thing that's the worst thing to do is total silence. When you're totally silent, that usually means you agreeing to everything as the debtor, and then you get an attorney. And then the attorney speaks for you. You're totally silent. That is the worst scenario you could be in any situation that I can think of. Now, I'm not saying attorneys are always bad. Sometimes you need them to negotiate, to talk to somebody for you in a private setting. When it comes to something that might be heading to court, you know, this is the antithesis of what society is told. Get a good attorney. I say become a creditor, not a debtor, and know how to act that way. And when we're going to give you an exercise, so by tomorrow, if you work on this, 24 hours from now, you'll know how to speak like a creditor in every situation. So get ready. We're going to show you how to do this. So be ready to take notes. So remember, always agree, basically. Accept. I'm sorry, there's a typo there. Always accept. That means essentially agree. That doesn't mean, okay, go jump off a cliff. I agree. No, it means I accept what you're saying. You're right. I made a mistake. But I didn't do it with any criminal intent. Or I might say, I accept what you say, but on proof of claim that I did it with a criminal intent. I meant no harm. You see, that's conditional acceptance rather than an argument. If your actions actually happened, agree that the action happened. But in law, they have willfulness is required for many things. It means you intended to do it with criminal intent instead of just accidentally doing it. Okay? Always accept responsibility and watch how much more powerfully things will go. You know, instead of sitting in court arguing over a bunch of facts, say, you're right, all those facts happened. But that's not the issue here. See, there's a conditional acceptance to the degree I'm saying, you're right, but. Every time you say, you're right, but, and without, again, making excuses, you're saying, you're correct, I'm totally messed up. But your law requires that I actually did it with criminal intent. Where's that evidence? I'll accept that you say I did those things if you can show me the actual criminal intent versus a good faith misunderstanding. And that's actually a very good excuse for innocence, the good faith misunderstanding. They have that built into their laws. It'll be in jury instructions in many cases. So they actually do follow this. You just don't know how to use it to your advantage. So conditionally accept. So agree, that is to accept, conditionally accept, or avoid denying and arguing. As soon as you find yourself saying, oh, I know what the law is about that, you can't do that to me. That's not the way to say it. You can say it a different way, but you've got to say, you're correct, I apologize for my errors, but I did read the law and it seems to say this, so if I'm wrong, please correct me. You see? Totally different tone, totally different way. I mean, your energy you put out is what you're going to get back. That's a law of physics. Okay? Remember, when we agree, they may not deliver you to the judge. That means settle it peacefully out of court. Judges frequently, a lot of court cases will say, did you exhaust all administrative remedies? They're talking about this. If you've heard any of this in court or any situations you're dealing with, you know I'm telling you the truth. They actually have a way of doing things correctly. It's us that don't know how to interact with them. So I'm hoping this lesson will help you. So be careful about what I call canned responses. A lot of people say, they sit there and replay, they're like a parrot. They say, I conditionally accept upon proof of claim that blah, 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 blah. That's okay at first, but you need to say it in more of a natural way. So think about going to the restaurant and ordering food. They say, well, here's your menu. Well, that's an offer. It's not just giving you a menu. It's an offer for a negotiation. And they say, would you like to order some food? Oh, there's another offer. Well, I conditionally accept if you can make sure you take the tomatoes off that hamburger and if you give me fry sauce with the fries. Can we do that? Yes, we can. Thanks. We now have an accepted agreement. That's what you're doing in court. That's what you're doing with the cops. That's what you're doing with all these situations. You just don't know it. If you don't know the game you're playing, you can't win. It's that simple. It's a simple negotiation. And the more you conditionally accept, the more favorably you'll be treated. You'll be seen in a higher status. That's what a creditor is, someone with a higher status. And no papers, no documents. Maybe you're using a driver's license, so what? How do you act is what's going to override that. Okay? So this always works if you do it earlier and start it early in the process, and you use it in every question and answer session that's going on, whether it's pre-court, whether you're talking to the prosecutor, whether you're dealing with the judge, whether you're talking to the clerk. Every moment you're in court, from the second the lights go on or the knock at the door happens, the court has begun. So begin acting like a creditor. Be upstanding, be confident, turn the other cheek, and ask the questions. You go back and watch, if you want to watch, a good movie on this is The Passion of the Christ. You watch, if you haven't read that or aspect of the Bible, I just read you some of it. Some of that comes from there. He demonstrates in that movie how he moves around, and a guy wouldn't answer a question. He was a great lawyer. He gave you a parable or a question or a challenge, but never really argued with anybody. He didn't make statements. They'd ask him questions, and he'd give him a parable back, because he was setting up what is the law here all the time. He was a great lawyer. You want to learn a lot? Learn Matthew. Matthew is full of stuff about the laws. Okay. So keep that in mind. So court starts when the lights go on, or it's a knock on the door. The most thing this always applies in many situations. You get a letter in the mail. When we do debt collector letters, all we do is we don't argue and say, "Go away, you dang debt collector! You're a third-party debt collector, and you're a fraud." No, we say, I'd be happy to pay this. That's what our debt collector letters say. If you can provide X, Y, and Z, but if you can't, it looks like the law says this over here, so you ought to be aware of that. I just want to give you a fair warning. But we want to work this out, let's work it out. But as soon as you produce that information, we can work it out. You see, it puts you in a whole different position. You just took the position of a creditor by a simple first response. So here's your exercise. Everybody, I want you to be a creditor for a day. And every interaction you have for a day, just try this. Push yourself all the way through the day. And this is easy. Within 24 hours, you can learn to do this. And next time you go to court, you watch what happens. If you're going to court next week, practice this every day between now and then with real people, just in everyday circumstances. And then when the judge speaks, it'll just come out naturally. Okay? Be a creditor for a day. Now, by the way, I learned this from I praise this guy as my greatest master, my greatest mentor taught me this. Be a creditor for a day. It took me a long time to get this. And then until I actually did it, and actually, I didn't just sit on this webinar and listen and go, "Oh, okay, that was great information. Okay, what's for dinner?" You at dinner time, pass the peas. Well, I'll pass the peas if you'll also pass me the potatoes. The other people won't even know you're doing it. But you just do it as a point of practice in everyday conversation. What I'm teaching you will teach you to be a greater business person, a greater negotiator, a greater salesperson, a greater father, a greater parent. I'm just telling you, this is powerful information. And you won't just be telling people that you're a creditor. You'll be showing it to them. You don't have to put a piece of paper in to prove it. You walk in there and do it. Okay? They ask you your name. Well, I'm the authorized agent for that name. I've been called that name, but I am the authorized agent for that name. Do you have any problem with that? Maybe ask a question. Try to turn it into a question. Sorry, I don't always do it perfectly. But try to be a creditor for a day. Every single thing that comes out of your mouth for the next 24 hours should be an acceptance or a conditional acceptance, or maybe a question. Hey, you want to pass me the potatoes? Sure. Hey, that's an acceptance. Perfectly harmless. But I'll pass you the potatoes if you also give me a fork or pass me the salt. Just do it, and people around you won't know you're doing it. But you know what? You find what happens is people start actually liking you more. I don't know what it is. It's just sort of a psychological game. But just do it. Okay? So do the day as a creditor until it's second nature. Before you go to court, practice this. You just start doing. You have to do it out loud. You have to practice. You can't just do it in your mind. You got to speak the words. Okay, if you're going to the grocery store, buying gas, can I fill that up for you, sir? Sure. And if you wouldn't mind, can you get the window for me? That's a conditional acceptance. It's that simple. All right. So and then as the scenarios come up in court, we'll practice that too. But the goal is to stay out of court. But if you are in court, this is a biggie. You're there not necessarily to win, but to build a record and build an agreement. Stop thinking about winning or losing. How do I build an acceptable agreement? Then you won't look at it when the judge turns down your objection. It's normal, but you built a record for appeal. All right? So maybe they do rule on something you don't agree to. You say, well, thank you, Your Honor, but I do object. For the record, and I'd like you to rule on that objection, because if they don't rule, by the way, it's not an objection. Don't forget that. Just by standing there and saying I object like a parrot means nothing. I object, and please rule on my objection. If they don't rule, then you have nothing in the record from which you can appeal. Sometimes people object and they forget that, and guess what? You can't bring it up in an appeal because you didn't get a ruling where they made an error. Objections are an offer and acceptance, folks. It's not a win or loss. Expect to have objections. Expect to lose objections, but build your record. Okay? And if you're conditionally accepting and then they're still trampling on you, who looks better to the appeals court? See? You expect in lower courts to typically lose most situations. But are you really losing if you built a good record? No. You've got an appealable situation. So this is why, again, we get back to maybe the self-help lawsuit course. It teaches you to be prepared for losing so that you can win in appeal. But if you don't build a good record with the right peaceful attitude, you'll lose. But when they see that you can go to appeals and you've got a good record, then sometimes only in those situations do they let you win, or they give you a better deal. You're negotiating a better deal just by objecting and building a record. Because in the end, they may give you something more favorable, especially if you were respectful and good and kind, but you're acting like a creditor. They will treat you like a creditor. That's the rule. It's not your documents you submitted. Way too much dependence upon that. Maybe we're guilty of providing you too many documents because you go, well, this document's going to do it and that document's going to do it. But you know what? If you don't have the creditor mindset, almost none of them will work, because you're still going to have to walk in there and deal with it. Like I said, if you're going to say, I'm going to express the trust, then don't do it until you can explain it to a 6-year-old, because you're going to have to, and do it in court. But do it in a way that's accepting, because that's what the bill of complaint is, in a sense. It's almost like an acceptance. So look at it again. So that's how to be a creditor. Now, if you want to put some examples in the chat window, and again, I don't want just a bunch of talk. I want people to give me examples of how you'd say it. I want to just make statements. See, if you're making statements in the chat window, you're not a creditor yet. Okay. Yeah, people are writing a few things. People saying, did you get my plea offer or whatever? Let's see. Let's see. I got to go back to some of these. These guys started this before I got. Hang on. I'm going to go back. I'd be happy to provide an ID and insurance if you can please provide me with your ID also. Very good. That's a good start. Hang on a second. This chat window, the problem with it is it jumps around on me and I get lost. I have to go back to it puts me at the end every time I start typing something. I'm on a free conference call. Okay, I agree that you might allegedly have standing, and will agree if you can present a valid proof of claim, providing jurisdiction to your claim. Okay. Now, if you know what that means, what do you really ask? We don't know what you're asking for, so if they do show it to you, you know what it is. I'd like to acknowledge your claim, but I'd like to ask a few questions. Okay, that's fine. David asks, where are the document links for this webinar? I don't know what you mean. There's no document link. You mean the document that's on screen? I'll save that in your, probably in the reference material section of the site. I'll let you know. This document's brand new. So let's see. Let's see other ways people put it here. I got a lot of comments in here. I don't need any more because every time you put it in, it jumps my screen and I can't see it anymore. I'd be happy to comply with your order as long as you give me the requested order in writing that's legibly signed and dated for payments to services rendered. And I might add, and as long as it's also got the correct full given name, not the non-de-Guer fake names, that they use, and the correct sentence structure, parse, syntax, grammar, and a full set of definitions so I know what it says. Just some conditions. Conditional. And that's the part they can't produce. Can you give me an umbrella statement followed by a series of questions? I'm kind of trying to give you some examples. There's no one generic example, but I'm giving you the idea. You have to go practice this. You'll get it after you do it for a day. You'll stumble through until it comes to you. It'll just come to you. It's natural, actually. Well, let's see. I will accept that I actually did what you are accusing me of if you can prove that I actually did what you say I did with a credible witness. Okay? If you can say a first-hand fact-based witness is another way to put it, too, because that's what they have to bring into court. Agree versus argue, creditor versus debtor. It's confusing because you do not want to consent to their authority, but you want to agree with them conditionally. Yeah, well, you'll get it. You practice this, okay? You're not consenting to the authority when you're being a creditor. That's what you get. Just the fact that you're there, okay? Get over it. The question is that could be part of what you're asking, right? I conditionally accept your offer to proceed with this traffic ticket hearing upon proof of claim that you actually have evidence, and I do mean evidence, specifically proving jurisdiction. Where's that? And they'll say, well, we have it. I said, no, sir, I didn't ask you for your opinion. I asked you for the evidence, please. That's a conditional acceptance, right? That's a offer, counteroffer. Just happened right before you, just like that. And you're by being the creditor. They don't have jurisdiction over creditors, guys. But until you show you are one, they're going to proceed as the debtor because you're going to act like one. All right. Still comments about the conference call test. Don't be there. I'll accept the charges against me if you can prove that I am a fictitious person, such as a corporation, or not a flesh and blood living being. Okay. They might say, well, what is that supposed to mean? Just be ready for the comeback to that one because they're going to play dumb. This is what happened to me today at the arraignment. Okay, you had an arraignment. What arraignment were you in? All right. I wish I would have said I accept conditionally. Yeah, or some form of that. I accept, but can we work this out? You always just sort of I accept, but, or well, that's okay, but you don't have to say the words I accept or conditionally accept. You do it by the way you phrase a sentence. Okay. Again, this is why you have to practice it for a day before you go to court next time, or you go to see the prosecutor and work something out. I tried to mention my conditional plea offer letter, which I handed in, but they still went straight to settling the case for trial. Okay, well then maybe you need to go ahead and start preparing how to do conditional acceptances during a trial. You can do it all the way through a trial. All right. Arlene, my concern is more about debt, mortgage, car, student loans, not behind. Well, you've got to correspond with those people. Work things out. Be a creditor. Let's see. All right. Let's see. David's asking all the. I got to get somebody else's comments. Now, like I said, David says, "Oh, I accept the charges against me for speeding and reckless driving if you provide proof of claim and damaged parties." Okay. Well, proof of claim of what? You might be more specific, but you'll come up with something. By the way, another way to do the acceptances is if you actually read the law, you'll find vagueness in the law. You say, yeah, I provide proof of claim that the law says this, and it's clear what that means. Make it clearer. They do it. They're intentionally vague for a reason. I can plead guilty after you plead guilty also, Mr. Prosecutor. Okay. That might be a little confrontational. Let's see. You know, as long as you're clearer, you know, be clear. You know, be reasonable. Let's see. Please clarify when you say they don't have jurisdiction over a creditor. How is this so? Please define what you mean by as creditor and how it looks within their laws. Well, I don't have a specific example of their laws. I have a specific example of biblical law and how the laws reflect that. And they do it in the form of terms like failure to state a claim for which relief can be granted, or did you work this outside of court first? Those kinds of things. They all have procedures. The rules of procedure do a lot of this. So it's very broad. It's built in throughout the law that if you try to work things out, you're far better off. My point is if you come in and you simply just lay down in front of them and say, I'm the debtor and I'm going to argue, you can't touch me, they're going to treat you differently, way differently. And you won't know until you try it. A creditor is the private citizen. A debtor is the U.S. citizen who they have control over. It gets into all those issues. I'm trying to give you the simplest 30,000-foot view way to look at things and not get caught up in the minutiae of all that. It's not necessary. But aren't they subjecting you to their law, and you don't pull you under their biblical references, as you say? I don't necessarily use the biblical reference. I use the principles. And by asking the questions, you're not saying, I'm the debtor, I'm the defendant, by your actions. You know, maybe it's a concept that's hard to get for some people. It takes a little while. Practice it. Do the day of being a creditor and watch what happens. Here's one. Happy to pay the ticket if you can specify what lawful species of money I'm required to pay. See, you're not going to find a law that says that's how you can say it. It's a principle. You brought up a good point in your question. See, when you bring up the points that bring up their deficiencies, that's how you win. I've always said you beat them on their deficiencies. So when your creditor response is point out your deficiencies, you just broke jurisdiction. If they break the rules, they lose jurisdiction. That's how it's a jurisdictional question. Okay? All right. So those are all good comments. Very good. So now those who are in the queue, queue to raise your hands. I'm going to be done with this session for now. I want to go ahead and grab those who've raised their hands. Hopefully you are asking, you have a success story. If you're in the queue, there's 508, Robert, Big Mo, Curtis, Danny. Hopefully you all have a success story to start off with. That's the first thing we're going to cover. Maybe you've used one of these techniques, something like this, something we've otherwise have taught. That's what you're in the queue for. So if I call on you and you don't have a success story, I'll ask you to drop out and come back. Okay? Big Mo says, looks like you're up. This is TJ. Go ahead. Big Mo, it says on screen. You're unmuted. Okay, he probably he's maybe either silenced, muted, or maybe he just went somewhere else for a few minutes. But you lost your spot. Okay, Curtis. Curtis is the next one up. Let's hear your success story if you got one. Curtis, go ahead. Curtis, go ahead. We hear background noise. You're unmuted. Curtis, you are up for a question. Is your mic working? Maybe your mic's not set up. It's always good to check your settings before you get on. When I hear background noise, I know you're there. Curtis? Okay, maybe he doesn't know he has his hand raised. Well, that's it. I had a few people drop out. So if you got questions, go ahead and raise your hand. put yourself in the queue. That uses the little microphone button, and as well as the *6 on your phone. Demetrius. Okay, go ahead.
Hi, TJ. How are you? Okay.
Good.
Having a good night here.
Good.
As you know, I told you I spoke to you about code enforcement and the grass cops. I was going over some material today. I got a little bit of information. Conditional acceptance. Can you use that for a municipality code officer?
You can use it for ordering McDonald's.
Really?
You can use it for court.
Okay.
You can use it for a pullover. Isn't your basic whole argument?
My whole argument
is what? Tell me. You tell me your argument as a creditor. What would you say to them?
Well, I would say we don't have a contract because
you just lost.
Really?
You just argued before your first sentence. You started arguing, and that's where they get you.
Okay.
Like in Jerry Maguire, you had me at hello. I got you out of the first 3 words out of your mouth. Let's try it again.
I would be glad to accept your offer if you can show me a contract that we both have 2 wet signatures, and you can show me a jurisdictional that you have jurisdiction.
Yeah, jurisdictional nexus, a contract. Yeah. Okay.
The reason I say that because in the cities in Florida, I don't know about Washington or any other country, any other part of the country, they have charters, and I've done the research. And Steve in Orlando, which you've had in your program before, he says that in their charters, the private homes are not covered. Code can't touch you, but they won't admit it. They did admit it to me 11 months ago when the city manager was there. I had a meeting with him, and he checked with his lawyers in front of us. Me and my friend Joe was there, and we brought the issue up. He looked at the lawyer, and the lawyer shook his head. They're right, and they didn't bother me for a long time.
Yeah. So you're this is why in your case particularly, because I hear from you a lot on this grass cop situation.
Yeah.
And I don't mean to be silly, but it's a good example of what we can get caught up doing. Yours is such a simple. I mean, I told you, go work it out. So that means, look. I don't want to fight you guys anymore. I turn the other cheek. So, let's see what we can work out. I don't think we have an agreement, but I'll conditionally accept that your assertion that we do. Can you produce it? And if not, what can we work out? Negotiate something. If not, okay, I'm still going to let you off the hook. I'm letting you off the hook. See, now I'm the creditor. I'm not the debtor. I'm not I'm not arguing too much. I'm just simply saying, look, apparently we don't have an agreement, but I don't want to argue with you about that. I'll accept that. Maybe my grass is a little too long. I mean, big deal. But what can we work out? What would you like me to do? Would you like me to get it cleaned up and then, and then just kind of leave it at that, or, pay a reasonable fine? Because I don't think we have an agreement. And then if you want to proceed where we don't have an agreement, then we'll have to change our discussion. That means I'm gonna have to sue you, right? But my point is, you keep the negotiating going, because in your case, I don't know what you knew beforehand and what warnings they gave you, or whether they have jurisdiction or not. They probably don't, but that's unfortunately we live in a society too where sometimes we do have to kind of help protect our neighbors too.
Well, TJ, it was every sign showed it was vindictive. They were doing it because I had a problem with somebody in another department. And when I went over to talk to her, when it was kind of late, this fine is $4,000.
Yeah, that's ridiculous. But say, look, let me get your supervisor. Look, I don't want to fight you guys. Whatever. I'm not going to make accusations. Just pull back from that.
Yeah.
And say, look,
let's
be reasonable about this. I mean, I don't think you have an agreement, but I'll accept that maybe we have to do something. What would you want me to do to remedy this problem? Instead of talking about money, you're just talking about action. You go get it cleaned up a little bit. Say, now, there you go. Now I don't want to hear from him again.
Yeah, well, everything's been cleaned up. I mean, and she wrote it up July 10th, but she added up the days. It was 62 days, and there was some areas in there that I didn't even know about. She didn't even know I had to go to court, not court, but a hearing, because she failed to tell me what needed to be cut. it was my
Yeah.
garden. My garden. She wanted me to cut my garden back, and I think you remember me telling you she had trespassed on the property.
Yeah.
You know,
Have other people complained?
no, that's the funny thing about it. When I went over to talk to her, she said, "I just want to let you know, sir, that nobody in the neighborhood complained about your grass in the back. It was the people upstairs in the other department that told me to go after you."
Okay.
So,
Well, like I said, my approach would be this. Go see if you can get it worked out, kind of just put it to bed. Show them you're a peaceful, not dangerous guy. Then if you feel like you've got to go to the next level, send them a bill and whatever for your expenses because they never approved jurisdiction, then you could go for your small claims thing. But never go to war till you can get it settled first.
Well, how does the small claims? I mean, do you have a right to take a code enforcement officer to do small claims?
I don't know. I guess I would research it, wouldn't I?
Yeah. Yeah, I don't know.
Anybody that steps on your right, maybe it's not small claims. Which may not be worth going to federal court, but federal court's where you have your rights arguments.
Well, that's going to be my final resort. As I told you before, I don't really want to go into federal court, but I'm prepared for it. I know what to do.
Is it worth it? I'm going to be honest with you. Would it be easier to try to work this out, pay a small fine, and just everybody go their separate ways and say, "But I don't want to hear from you again." That's part of your offer.
Yeah, it could. Yeah, but I don't want to agree on $4,000.
No, I agree, but it's going to cost you more than that to go to federal court in the end.
Oh yeah. But
unfortunately, it's the lesser of two evils sometimes.
It is. You're right. Probably, doing a small claims court, it makes a lot of sense to me. But
small claims is good as long as you can establish that you have a cause of action. That's substantial for small claims. In other words, a cause of action that fits into the small claims realm of authority. Okay. Yeah, you determine that by research.
Her communication with me was utterly ridiculous.
Well, it's not surprising. But listen, I'm gonna get you another caller.
Okay. All right. Thank you.
Take action on that. Okay.
Yeah.
All right, next caller is one that says anonymous. Ooh, one of these mystery people.
How's it going, TJ? This is Blake. Sometimes it goes anonymous when I log in, right?
How's it going?
It's going pretty well. It's a great call. Conditionally accepting things is the way to go, as you know. I had a quick question. In relation to really bonds, I know in one of our processes, we actually can go into court and ask for the bond as a creditor, and because technically it is ours when we ask for it. My question is centered around, and that's I think geared toward the bond that the prosecutor is supposed to bond the case over. Call it commercial energy. But my question is in regards to an appearance bond. In terms of, so I've been not threatened, but the defendant or the straw man or the, whatever you want to call it, has been warned that an appearance bond may be forfeited if he or she doesn't appear, or it doesn't appear in court. But I guess my question is around, to me, it would seem, and I've already conditionally accepted this offer with the syntax. Conditional acceptance.
That's a conditional acceptance. Yes. Okay.
But my question is, I'm thinking that I really want the bond. It would appear. It seems.
What do you want it for? I mean, don't you just want to be out of there?
I do.
Okay, don't get too far off base. You got to work something out and just say, look, what is, you got to use the bond. Hey, the appearance bond, all that is, again, I don't know. Did you pay a bond? Is that what happened?
No, I didn't pay a bond.
Okay, but you probably signed a release agreement. That's also an appearance bond.
Right, or cognizant. I think.
Yeah, and even if there's no fee involved, it's still an appearance bond. You're agreeing to terms and conditions. It's all contract to appear at a certain date and time, and then, if you're not in honor, they can do whatever, they'll come after you, and so should they. So
Yeah, to your point, I mean, yeah, it will make more sense not to go that route. I was just curious as if that was something that's kind of common, but
Well, you're a creative guy. I can tell. You know, you always come up with creative ideas, and that's not bad. But sometimes you have to go for what's the path of least resistance, even if it's going to cost me a little, because it's going to cost me more just to keep fighting too. There's always a cost to that, and I'm not saying everybody should give up. I'm saying give up with control. You know, you win a football game, it might be 41-42 game. The other team got 40 points. Oh my God! But you won.
right.
So always remember that it's the W you want, at least at some level, not just the points. So.
Okay. And then on that, I mean, I'm almost done. But on those lines, I mean, on the lines of keeping it simple. So I always start any sort of type of offer with a counter offer, conditional acceptance. So
Yes.
in a matter of like a ticket or anything, I mean, I got some tickets, so I obviously syntax those, and that's my conditional acceptance, and so that that's all by itself its own court. But I also mean expressing the trust makes a lot of sense to me, especially what I've already been in court and essentially expressed the trust.
Mm-hmm.
Maybe not in a super formal way, but the concepts that I've asked questions about certainly outlines a lot of the things that are in expressive trust. So I guess it's in your opinion, this is not obviously legal advice, but would it be kind of convoluted to express the trust while still having the syntax contract already settled and out there as well?
Yeah, I mean, if you're mixing stuff together, you're getting off point, and once you get off point, then you're beginning to look like a debtor again, even if you got the right idea. So I'm very careful about throwing everything at the wall. You need an arrow to kill a deer, not a shotgun. And if you got a good plan, stick to it. As long as you keep the essence of it being that, when you're expressing the trust, you're saying, "Hi, I understand. I want the court to understand this is what I'm here doing. This is how I'm appearing. These are my conditions, and as long as the court is ready to proceed, I'm here to help you get this settled. I'm here to help. You're not there to fight. It is absolutely not an argument when you're doing expressing the trust. You're just pointing out the relationship of the parties. And when you're saying I'm a beneficiary, you're saying I'm a creditor. Right? The beneficiaries create the corpus of a trust. The trustee's job is to pay. But if you don't claim that position, they flip it on you, and you become the trustee / defendant / debtor.
Okay, I remember
that quickly.
Right. Okay, that makes sense to me. Because if anyone who's ever had a syntax claim and they've submitted it to the court, they know that they're not going to bring that up. And so,
no.
I mean, in the background, that contract's being acquiesced to. So, I mean, then you have your small claims. So you can do that in the background. And not necessarily convolute the matter if you want to do for instance express trust. That's probably what I end up doing.
Yeah, and this is I can't stress enough. You got to go to your brother and try to work it out. Matthew 18 verses 15, 16. Yeah. That means if you got to go to the prosecutor and say, look, I know I sent you a copy of this. I sent it to the court. Now I sent you a copy, so you'd know what's in the court. What is it we can do to work this out? Right. You're not admitting anything. You're saying, what was it we can do to work this out? Like I made some mistakes, no question about it. I'm not, I'm here to get this thing taken care of. Not agreeing. You're not admitting guilt by accepting. You're accepting the responsibility to settle it. That's a different scenario than saying I committed a crime. You might even say, well, the facts of the case are, I don't deny that happened. The question is, what was the intent, or what was the, but what is it we can do to just work this out so we don't have to take this to court? The kind of thing that's not like, a murder charge where they're trying to reduce it from a murder to a manslaughter. He's still going to jail. Mm-hmm. I mean, I want to take responsibility for my actions, but this needs to be reasonable. So I just want to see what we can do to work this out. And he says, are you willing to admit guilt? Now, see, there's an offer.
Right.
Now, you have to be ready for that.
Or are you representing yourself?
Well, I don't know how to do that unless I bring a mirror. That's representing myself. That's me over there in the mirror, and that's not me, and here I am. Yeah, that's representing myself.
Yes. Do you have a mirror? Yes.
Okay. Take a mirror to
well,
court at all times. Yes,
right.
I am representing myself. See? Look in there. That's him.
Here we go. And then one last thing I just remembered. While expressing a trust, one of the whole ideas of expressing a trust is obviously to obtain the age of majority. And it's perhaps that maybe I missed this when you've explained this in the past, but when I was reading this is actually on page 9 for anyone who's maybe in the document themselves or reading it. But it talks about in order to attain the age of majority, having the birth certificate along with attaching an affidavit attesting to obtaining the age of majority, with specific language.
Yeah.
I don't recall us mentioning that, but it makes sense even in reference to 2 weeks ago when we're talking about doing the explanatory statements with the national passport.
Mm-hmm.
I guess it's not really a question, but it's just something that I noticed. I guess it certainly wouldn't hurt to bring a certified copy of a birth certificate along with an affidavit with this process. I think that.
If it makes sense to you, it makes sense to me.
Yeah. Okay.
You're the one telling the story. It's your contract.
Yeah, that makes sense.
There's no rule that says you have or have not to, but if you read that, it makes sense. You say, hey, you know what, this makes sense. See, when you make the decision, it'll usually work out. It's not when I tell you to do it.
Right, exactly.
You know how it is.
Yeah, the volition, right?
Yeah.
Okay. Well, that's all I had.
Your energy. Yep. All right, thanks, always good. And by the way, if you do some work on that trust document, expressing the trust document, and you see it needs removed from improvement or cleaning up or shortening or cleaning up, whatever, always be prepared. Send me a copy of what you come up with.
Okay.
Yeah, I can always improve upon it.
Yeah, I found just a couple little typos, but nothing out of ordinary. So
nothing bad. I know all my stuff's going to have typos. It's just not intended for anybody to just take without retyping it. It's meant to be edited so that you own it.
Exactly. Yeah, if I think of some conceptual stuff, I'll definitely let you know.
Okay. Yeah, I appreciate your feedback. I know you do thorough work. Okay, thanks.
Thank you. Alrighty.
Bye. If anybody on the planet needs to be proofread, it's me. But that's because I'm working on volume sometimes. All right. 508, Robert. 508, Robert. You're up.
Hey, TJ, how are you? Yeah, I'm here.
Hey, how are you?
Can you hear me?
Yes, I do.
I'm good. Okay. My motion for judgment is tomorrow morning.
What are you working on again?
I didn't pay a credit card. Moral law. They're laundering drug money, and then they were told to cease, and then they paid $100 million in 2018, and I don't feel as though my labor should, pay them any money, and I kind of hit the hornet's nest with my answer, so I admitted to taking the card and all this stuff, so then, but I didn't admit that I owe money it's a moral law, I just don't feel like I should pay these people because, they're just laundering drug money, and they're paying $100 million to the Department of Justice, and they're just going on with what they do.
Yeah.
So
kind of what goes on.
So I'm a fighter. I understand what you're saying. Turn the cheek, all that good stuff. But
there's a place for that. And there's a place to, just say we got to work this out. Let's prove the claim. But I'm happy to pay you. Prove the claim. Prove. And credit cards, there's a million things that they can't prove.
That's
and
the
make
thing.
it about that.
I got my statement, and I'm definitely prepared. I'm going for the appeal, so I'm trying to go in there.
Did you get a lot
tomorrow.
of objections on the record that were ruled on?
Well, tomorrow morning is when I get my first shot at this. I wish I came to your site before I put my answer in, but I didn't. And
because the answer should be, by the way, a little tip on answers to suits is you don't answer, you motion.
Right.
That actually waives jurisdiction when you do that, and then that keeps it going.
Well, actually, I read all the motion laws, and of course in Massachusetts, they, you know, they have these little rules. You got to put an SP by if you're representing yourself, or they throw out the motion.
Mm-hmm.
So when this guy,
local rules, very important.
Well, 180 pages I read, and I saw that, and they had, you know, an exemption for commerce, and they also 7-1, the 7-1 rule I learned about from your site. They exempt that. So the guy saw my answer, and he immediately put in, a judgment because I admitted to a few things, and they gave me 13 days. I put in a motion, but I know he's just going to throw it out because I didn't put the SP something after my name for not being a lawyer. So my motion was ridiculous. I tried to write some more motions, and I realized, this isn't going to go anywhere. But I do have what I'm going to say. I don't know if that's okay, if you want to hear what I'm going to say. I'm going to try and go in there, and I am here on that matter, and just do a lot of talking before they can go ahead and hear the motions. They'll throw out my motion, and then they're probably going to approve his motion that I have to make the payment. But,
so it's a summary judgment. So the summary judgment. Where's the trial by jury? Where's the jury of your peers to rule on a matter that over $20, per the Constitution?
Well, I do have at the very end. If he doesn't, there's so many. I got like 6 motions to dismiss all lined up. Okay, so so I can go to appeal. I'm expecting to go to appeal. These people are not going to bend over for me. So
well, remember, the only thing you can bring up in appeal are objections and rulings on the record. So keep that in mind.
So if I say
appeal is not a second place to hear the trial. Appeal is to hear objections and violations of process as a result of those objections only. Those are the only things you get to put in an appeal.
So every time I say I motion to dismiss and he objects, I have to say, put it on record, your objection.
Well, yeah, that's more or less. And usually when you make an objection, you say, I object, and they're going to say, why do you object? You say Rule 407B or whatever. You have to kind of have it down to that fine of a, because you have to show how they violated the rules. Or if the only testimony in the record is the attorney's own testimony, which will be the case, you bring up Trinity versus Pagliaro case, Supreme Court case.
The question is
that statements by counsel are insufficient for judgment.
Can I read you what I plan to say before any of them can talk?
No, not right now, because I don't want to get into too much reading like that kind of thing. But just make sure you have a comfortable understanding of what you're trying to do. Just make sure you're trying to get to getting objections in the record. So without an objection, you won't have an appealable case. So I'm not so concerned about what you say. I'm concerned about what you do when they say. Their burden of proof is on them, not you.
Right. So that's what I'm trying to do. I'm trying to get the attorney to show me his proper authority, consent to proceed. I'm trying to get him to bring in his...
I don't know, how much have you used of our credit letters? There's a ton of the conditions on those letters about what they should be able to have to prove a claim.
Right, 21 days to respond in writing, provide me proof of claim evidence.
Bring the original contract, if there's a licensed attorney, provide me a proof of your license, not your bar card.
Yes.
Stuff
I'm
like
trying
that.
to buy time.
Yeah, exactly. Just... maybe that'll buy, put enough of those points on the record.
And if he doesn't have, like, the validation...
May not let you go very far with that.
They won't?
Unless you got a motion that's written and you can kind of go through the motion and rule on it.
How about the attorney anti-bribery statement and foreign registration statement? I expect that
might be something. They probably won't push too hard to make him produce that. They will say, what is that supposed to mean? He's not foreign. You got to know what you say. When everything you bring up, you got to prove. So, ready.
What I'm going to, I got the Title 8 UCC, the Title 22 UC, Chapter 11, 28 Title 28.
Well, are you writing
citing,
a motion? Are you writing a motion to dismiss for failure to state a claim? And here's the reasons. Boom, 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 boom. I mean, that should be in there.
But there is no time for me to write motions. I'm just
telling you what I would do. I can't tell you as far as the time. The response has got to be something that's going to move the court and create a record.
So
whatever you're doing,
mm-hmm.
make sure that's where you're going with it.
So have the motions written up.
Yeah, and you'd have to have it in the record prior to the proceeding.
Yeah, nothing's gonna. They gave me 13 days to get ready for this.
Just tell them, say, I do have some additional procedural motions. I need some additional time. Go in there and do that.
Okay, I could try that.
They can, and then that will demonstrate the lack of due process. Again, I don't know what the state rules say and require, because they're going to go off that. You might say, according to rule blah, 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 the Massachusetts blah, 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 says I've been given an additional extension of 30 days upon request. I'm hereby making that request. You got to state it like right out of their rules.
Geez, I don't even know where to find.
Well, yeah, it's hard to answer questions for things that are happening tomorrow because you don't have much time, but I'm just telling you what you have to do to prepare to go to court. Know the rules. Use them.
Yeah, they exempted the 7-1 rule on commerce, so they gave me 13 days to prepare.
13 days to prepare for a suit? Well, there must be more time than that's been going on with this thing.
So, at the end, I just Article 7. I request that I not be denied my 7th Amendment right. Article
Something
7.
like that. Again, it's better to put it. Always say things in the form of a motion. I move the court for this. I move the court for that. You don't plead. You don't. What are the people? There's the term people use, and I never use it. It's not plead. It's
See, the whole reason was to get a jury trial.
Yeah, see, I want a jury trial, Your Honor. Decide. Yeah. I'm not ready to proceed. I want a jury trial. Just say that. Again, I don't know what the rules are. That's where you have to pull out a rule and show them you're right. When you compel them to their rules, then they'll pay attention. If you just make general statements, they'll say, "We don't hear that," because they don't hear it. They don't have to.
Right.
That's what fiction court's all about. It's got to know the rules.
Well, I got my birth certificate, and I'm here under special appearance and all that, cat name. Yeah. None of that's going to matter. I'm a living man.
No, because they'll just simply say that the defendant didn't appear. You're already in it now. You got to go in there and beat them on the rules. And you can beat them on the rules, but you got to know the rules.
Right.
I mean, is this your first appearance?
Yeah, first appearance. They're motioning to... It's not even a jury trial. They're just motioning to make a ruling on the claim because I said some stuff in my answer that gave them statutes that they write.
Yeah, if you answer, see the biggest mistake to make in a suit is to answer. You should be motions, motions, motions. It's called flurry of motions. That's the strategy, and then that never grants jurisdiction by entering those motions. You're just simply wanting them to prove jurisdiction after this, that, and the other thing, whatever record you're building. But that's the basic strategy with a suit is you do a flurry of motions without answering. Because the answer starts the clock.
Right. All right. Well, I thank you very much for all you do, and I appreciate your time tonight.
Well, good luck tomorrow. Maybe something good will come out of it. But if anything, just say, Your Honor, I'm just simply not prepared. I'd like to have more additional time. But again, I don't know what the rules, I don't know where you're at in all this. So maybe you look at that. Maybe you look up that rule.
They pretty much exempted themselves from the statutes of 14 days, 21 days in commerce and a bunch of other stuff that they deal with.
Yeah, they're really good at knowing those rules.
Yeah, they are.
They beat us on the rules all the time. Yeah. Okay, well, it's not going to run, but good luck. Maybe something good will come out of it. Let us know. You have to get the extension. Okay? All right.
Thank you.
Bye. Tough to overcome past mistakes, I know. Another anonymous.
Yes, can you hear me?
Yeah.
Yeah, unfortunately, I didn't have an option to do anything else, but say it just came up anonymous. So.
Okay, what's your first name?
Oral. Actually, you answered an email that I'd sent to you in reference to the bonds about a week ago or so.
Okay.
Yeah, but anyway, that's not what I'm calling about. What I wanted to know is in reference to attacking them on the car note thing, because I send in a payment to tender the payment, and they never returned it to me, and they just simply said they destroyed it, but then they came and they repoed the car anyway. So I've been trying to actually threatening to sue them, because I use a couple of the letters to say to show a claim, and they just pretty much send a generic copy back of the contract, but that's all they ever do.
Right.
So where do I go to move forward? Because I do plan to take them to court, but how should I
car
go?
repossessions are really tough because they have the title, they got the papers, you gave it to them.
But it was an unfair contract where it was not full disclosure in the contract.
Okay. Did you sue for that?
Well, that's what I'm. Yes, I'm actually mentioned. I mentioned that in my paperwork that I didn't receive full disclosure, and I actually asked for full disclosure, and all they do is send the same generic copy of what you signed.
Yeah, yeah. Well, again, you have to show. You have to somehow, if you make an accusation when you become a plaintiff, you got to prove the existence of that. It's not like, when you're still playing defendant, where they're coming after you, coming after the car, you're in court right then. When they send you a letter, you're asking for proof of claim, and that proof of claim should include X, Y, and Z. And of course, they don't respond with that. They just ignore. They just wait till you default. That's how it's played. And the part about cars in particular, it's kind of like mortgages. They got a piece of it already, so they only need you to slip once, and they got it.
But the thing is, I did actually, I settled it with a tender offer. So I did.
Okay.
Yeah, so I showed that because I send registered mail return receipt, and I show that they did actually sign for it on 2 different occasions. And if they didn't, if they rejected,
well, then at the very least, you can say you sue for the return of your tender, or they pay you for it. Send them a bill.
Okay. That's what I needed.
And if you don't pay the bill, then you have grounds to sue. You don't have grounds to sue until they don't pay the bill. See, I think you'll lose if you try to argue over their contract issue. Ultimately they'll just keep going until you go away.
All right.
But if you can say, hey, I billed you for my tender, I'm going to return my instrument. You don't have the right to return you destroy my property. Call it property. It's a contract.
Because it is. Yes, it is. You're absolutely right.
It's a contract. Yeah. And then now I'm suing for my property, return of my property. Oh, you destroyed my property? Well, very well. It looks like you said so in this letter here. Okay, well, I'll give you 10 days to pay, or I'll have to take you to small claims and sue for it.
Well, I'm planning to go to big claims because I'm going to sue for more than. It was for $18,000. So.
Okay.
Yeah, but and one more question because I know other people are waiting to ask you questions.
Have a good cause of action written because the court will work against you on that. So make sure it's well documented. Have a good cause of action because the court will work hard to rule against you on that.
Oh yeah, I have documents. I send everything.
Cause of action. Those are when you go to sue, it's all about, you get that how to win in court without a lawyer course, and it'll tell you how to write a suit.
Okay, I'll definitely do that. And one other question. Now, we speak a lot about birth certificates. Now, for myself, I was naturalized. I wasn't born in the U.S. So is it the same concept as far as...
Generally, your naturalization certificate is...
That's what I was thinking.
You were birthed into the country. You came through a port of entry.
Right.
Your port, again, listen carefully to the words. You came through a port of entry onto a state, some jurisdiction, through the Department of State, and you were given a. You're no different than anybody else that was just simply born. Yeah, they were born in a hospital, but they were then also birthed into the state through the Secretary of State, just like you were.
Okay. Okay, that's what I was thinking.
You understand the admiralty nature, maritime nature of law,
right?
And how they convert you into a vessel that's operating in commerce, and that's okay to have a vessel to operate in commerce. You just got to know what the hell you're doing with it.
Okay, so in other words, I shouldn't even try to use my natural birth certificate. I should use the naturalization certificate.
I would probably, depending on the nature of what's going on, I would use both.
Okay.
One created the other, so just I always say if in doubt, over notify. Whereas the Navy SEALs say if in doubt, overkill.
I think that's what the cops do here too. But anyway,
yeah.
Thanks a lot, DJ. You helped me out.
All right. And a reminder, everybody, that the self-help lawsuit court, our link to, so you use our affiliate link over to their site. It's not our site, it's another site, but you can use our link to get it. Is urlaw.org/JD. urlaw.org/JD. We have links to it all over the website, but just in case you need it, can't emphasize enough how important it is to go through that course along with what we're teaching. So they don't give you ideas like we do. They just simply give you the procedures and then how to find rules and things like that, because you'll lose on that issue. It's the best course out there. We decided never to try to write and compete with it. We work along with Dr. Graves. Dr. Graves, we've had a working relationship for 10 years. And I just really love his work, and he likes our work. So, it's a good tandem thing to have. So next caller is Ed. Ed's our last caller in the queue. Ed, go ahead. Yeah, I got you here. I think so. You're unmuted, Ed, on my end. Maybe you need to unmute your mic, or your audio settings aren't working. If it's not working, you need to kind of reset. I can knock you out of the queue. You can reset your mic and then come back in. Ed, last chance. Going once, going twice. Kick your heels together 3 times, Dorothy, and go back to Kansas. Okay, Dave. Dave, go ahead.
Hi, TJ. Can you hear me?
Yeah.
Can you hear me?
I can hear you okay.
Okay, sorry. I don't have a very good internet. Okay. I did the jurisdiction challenge at arraignment. I filed motions a little late, like yesterday. I filed a motion to dismiss and a discovery request with Brady method. It's found in under the traffic folders.
So let's start at the beginning of the story. Let's start at the beginning of the story. This is a traffic situation. What kind of traffic situation?
Yes. It's speeding with a reckless driving charge.
Okay.
Yeah, speeding, reckless, and seatbelt. It's like they threw a lot at me.
They always do. Yeah.
So I did get
hang on a second. Let me ask you another question first before we get into the technical stuff. What happened? You were driving down a road at what speed over the limit?
Yes. Okay. The roads here where I'm driving on are kind of just a 2-lane road with a dashed line, and the speed limits go up and down frequently, and it's easy to be caught off guard, and the cops usually know where the speed limits are reduced.
Yeah.
We use a lot of radar. So it was a 2-lane road, and I was unaware the speed limit was reduced. I went to pass what I thought was a slow vehicle, but the person was they slowed down for the speed limit reduction. And when I passed him, it just happened that an officer was coming the opposite way with his radar on, and he got my speed as I was passing.
Mm-hmm.
So assuming the speed limit was 55, like I thought it was, then I might have only been like 10 miles or 15 miles over the limit when I passed. But the speed limit had just gone down to like 45 or something. So it ended up being like 30 miles or 25 miles over the limit, which I think creates a reckless driving. I'm not sure.
Okay.
So that's
kind of what happened. Okay. I got it. Okay. So now you said you just went to an arraignment. So you just said with the Brady.
It went for arraignment today, and I wasn't sure what to do. So trying to keep it simple because I'm kind of new to this. As tempting as it was to throw a flurry of things at them, kind of like see what sticks. I understand that like they're going to test you, and they're not going to just roll over and go, oh, okay, like just dismissed. They will try to ignore your motions and your
what's particularly an arraignment. I mean, really, an arraignment is only to hear guilty or not guilty, whatever. I mean, I say sometimes if you don't know what to say, it's okay to say not guilty. Then you have time to work out your emotions. Don't be afraid of that.
Are you saying that I could work on my motions more between now and the trial date?
Of course. You start motioning to dismiss.
Because what happened today was
started when lights went on
for trial, and I didn't actually enter a plea.
Oh, you did not enter a plea? Did they enter a plea for you? They'll just assume a not guilty charge if you proceed. They go by your actions, not so much always your words. So, maybe defective. I don't know what the rules say. Now you have to do some investigation.
The audio cut out for a second there. I didn't hear.
Yeah, yours is cutting out actually on your end, but you might have to enter a plea, and you've already effectively, if you got a trial date set, they're assuming there's a plea there anyway. But that's when you start doing your motions. Start putting everything in, and then go to court and stand on it. Say, well, I'm not ready to proceed until these motions are heard.
Okay. So even at the trial, I can still stand on those motions based on jurisdiction, proof of jurisdiction, right?
Well, I would look up the rules to be sure that's how things can work.
Okay. Yeah,
It's your motions. You're in trial from the second the lights went out. You're already in trial.
Really?
You're already in court. You're in court from the second the lights go on. That's when the offer is made. You're now in a contract. So you're still negotiating. So keep negotiating.
Okay.
So condition accept your offer that all this happened from the claim that there was jurisdiction established. Number one. Number two, that whatever factual basis you want to bring into it, that's another way to deal with it. There's some errors in their facts or timing or whatever else you can prove.
So what I'm trying to accomplish here is demanding certain things from them that they cannot provide, and then ultimately they find me guilty regardless, and then I file an appeal.
If you made objections that you can appeal upon.
Okay.
You can't appeal a case because you lose. You appeal because of objections that were violating your due process. You got to make those objections, or you don't build a record to appeal. They'll throw it right out.
Yeah. So this whole jurisdictional challenge is to create that basis, right?
Partially, yeah. That's one of them, yes, because you're denying your due process. You expect to lose these initial stages. They're going to keep moving you forward, but that's what you're doing is you're building a record. You're building it from the second they pulled you over. Okay. That's why we'd say on the side of the road, well, so long as you can prove, your officer, that, I intended to do something reckless, and then you built to put that in the record. They're recording that.
Now, are the judges, or are they?
Maybe it was unsafe to pass without going that speed because there was another car coming head on. You had to get around them.
That's exactly my logic. Is I don't want to be in the oncoming lane.
People win traffic cases all the time on those little technicalities.
Yeah.
I mean, and if you just look at a typical traffic ticket, there's also issues on those typically as well. But that's why when you start building your record from the second you get pulled over, it says, did I do something wrong? Well, you were kind of going fast there, weren't you? And people go, well, was I? Instead of saying, well, was I? They say, well, how fast did you think I was going? And they'll say, you were going this fast. And you kind of keep going, was I? Wow. Didn't realize I'd gone that fast. You know, I said, is anybody in danger? I want to be sure nobody's in danger here, you know. And you just kind of play the creditor. But most people start just coughing up information. They rely on your testimony when they pull you over.
Yes. I've made that mistake many times.
Last time I got pulled over, I said, "How you doing, officer?" He says, "Oh, your lights are off." And I said, "Oh, they are? Well, I'm sorry about that. You know, as you can see, I can't even see that bright thing through my steering wheel, so I'll go ahead and flip them off now. Anything else?" You know, and I was just like, very, very nice. I said, "Would you mind standing a little bit out of the road? This car's kind of close to you, you know." And I was telling him that, you know, and that's how you act. Treat him like a real nice guy, brother, and just say, you know, I apologize, but I don't think I had any intent to be reckless, though. I mean, that can really hurt me if you put that on there. Is there any reason we just can't just leave this as a speeding ticket and let me deal with the court just on that basis? Yeah. You know, you just kind of have to.
I did say something to that effect.
You don't admit anything.
But by the time initially he said it was speeding. When he came back with the citation, he said, "I also charged you with the reckless." And I said, Whoa, you know, I wasn't trying to be reckless, you know, it's a simple, you know, misunderstanding.
Well, there's an intent issue.
And I said, you know, that would really hurt me. Is there something you could do, maybe just make it just a speeding ticket? And he said, "Oh, I already submitted it electronically. It's done by computer, so there's nothing I can do."
Well, then your argument, you're still but that's part of your court process. You're still in court now. That's where your motions come in. See, I'm ready to admit guilt. Here's my conditional guilty plea upon proof of claim of boom, 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 whatever your issues are. That's a conditional offer. You're saying, "I'll plead guilty." They can't get you to court if you're pleading guilty. But you're not pleading guilty. You're saying, "I will conditionally plead guilty if." They don't like that because it puts them in a quandary.
They can't get me into court on these conditional pleas. They can't get me.
Well, it'll be hard, but most people just end up still stepping right into it because the court will say, "Oh, we're going to do it anyway." I said, "Well, I'll accept your offer that you can take me to court if I'm entering a guilty plea." But I just have a condition. I have a condition. You have to get back to your guilty. So I'm willing to offer a guilty plea on the condition that you know, that maybe you just drop these additional charges because there was no intent. There's no evidence of intent. Nobody can prove intent.
Yes.
Intent is the issue. It's not the action. It's the intent.
I like that. That's a good point. And then what about regarding? What about
You'll probably
my
be able
motion?
to settle that with the prosecution.
Don't they have a deadline to respond to my motions in writing?
Probably.
And my discovery request? And
probably.
Could I then, when they fail to do that within the number of days allotted by the rules, local rules?
You want to cite those rules in your request. If you can look them up and then cite it in your request. So it's right there in your contract. You're writing your contract and you're negotiating. But use their rules so you're fair. We want to be the creditors, the fair ones, the ones in charge.
Yeah, I've been trying to find the rules on that, and I am on the Kentucky Revised Statutes website.
Keep looking; they're there somewhere.
But it's just a lot to look through, and it's
a
little weird because
when you start specializing what you're looking for, you'll find it.
Okay.
Anyway, any other question? I got another caller. I'm running along here.
Okay.
A lot of questions.
So the last thing I just want to ask on this is, if they default and then the rules support that, that could be grounds for dismissal without ever going to trial, right?
If that happens and if you move the court to do it, the court will do nothing until you move it.
Yeah.
Will not do it for you.
Be aware of those dates, right? Find out what those.
No. Actually, no. You don't need to know the rules. You don't need to know the dates. You should just guess.
Really?
Come on, man. Listen to the questions you're asking me now.
I'm sorry.
I'm not trying to pick on you. I'm trying to point out. You're asking me obvious questions that you've got to use those common sense and logic. If there are rules, maybe if I hold them to the rules and they break the rules, I win.
Yeah, I'm just basically wanting some validation that that's how it works because I'm new
I don't know if that's how it works. you're asking the wrong guy. I don't live where you live, and I don't know anything about Kentucky except to make bourbon there.
Well, I mean, these things are generally true all across the country, aren't they? The idea that the court has
what is
ruled
true around the country is that there are rules.
Yeah, and they're generally have in my experience, from what I've seen, is because if it wasn't true, then these things you're teaching wouldn't apply so generally across the country.
Generally, yes, but you need to know the specifics to use them.
Yeah, the specifics you find in the local rules, like the deadlines and things, and how to move
There's the state statutes, and then there's the court rules. You got to look at both.
Yes.
It takes work.
But so I guess in general, it's commonplace, right, for a motion that goes unresponded to or a discovery request you could move the court to dismiss, right? I mean that would be a potential.
If they break the rules, you can't move the court to do anything.
You're sarcastic.
If they break the rules, you
Yeah.
win. That's the way it works, and they break the rules all the time. This is why I've got a video out there. It's an old one. It talks about defects. Focus on defects right out of the chute, and find the defect. And that when we do the syntax and stuff, it's all about defects. But also, you can just find generic defects that are just obvious. There's just little things that you can look for procedurally. Did they search the car without a warrant? Or did you ask for a warrant first? If you don't ask for it, you don't get it. So it's like a genie. You gotta keep asking. You gotta keep moving him. Tell him what you want. Okay.
Okay.
All right.
I appreciate that.
No problem. I'm just trying to teach. So I'm not trying to pick on you, but that's how I teach sometimes.
No, you definitely. Yeah, it was excellent. I appreciate it. Thank you.
Okay. All right. Take care. 862. It's like somebody named Joel.
Hey, good evening, TJ. How you doing?
Good.
Thanks for taking my call.
You bet.
I want to say thanks and kudos. I actually just had a case. It was filed in New Jersey, a Superior Court, where the plaintiff in a matter, I used subrogation as a matter of fact, with a motion to dismiss under a bill of complaint. Subrogation. And it worked fantastic. It was spot on. This entity, Comcast, tried to actually have me give them my Social Security number as part of a settlement agreement. And I knew you can't do that. Actually, I have to read on your site that it's a felony, punishable 5 years, to try and compel disclosure of a Social Security number.
Yep.
So I put that into my motion to dismiss. Now, when I questioned the judge about trying to get his oath, he said that New Jersey predates the Constitution, so they don't follow the Constitution in that court. He literally told me that.
Okay. Well, lawyers are lawyers. Yeah, he's a lawyer too.
But it was so beautiful. So I asked him, is New Jersey under the Supreme Court? Does New Jersey have a Supreme Court? He's like, yes. It's the Supreme Court followed the Supremacy Clause of the United States. He's like, yes, and they decided to go to some other babble. Like, okay, whatever. So anyhow, my question is this. I put in a motion to dismiss, and I with a special appearance. It was a packet that someone else contributed to your site, and I thank them for that, because it worked masterfully. And in the motion, I also put in a bill. I actually requested a glass of orange juice, too, which they didn't give me, so.
All right.
They broke my contract.
Well, see, now you at least get the concept of what you're actually doing. You're just negotiating a deal. Yeah,
yes.
That's right.
Okay, so in my bill for damages, now, I submitted it. My case was Monday. I submitted it Friday. I asked for a hearing. They scheduled a hearing for Monday. So now the plaintiff, the judge made an announcement that there was my motion to dismiss, and the plaintiff's attorney did absolutely nothing to either confirm it, to oppose it. My question is now, he dismissed my case for subrogation, stating that it wasn't cognizable in his court, and neither requests were. So, does my bill still go into default status if they do not address it within 3 days, or is it dismissed because of the dismissal?
Well, certainly. Did you object to that?
To dismissal?
say it's not cognizable in his court, and he's actually technically
Yes.
correct.
Oh, yeah. Objected.
Publicly.
Yes, I did.
Okay.
Yes,
Good.
I did.
Then at least you got the. Did he overrule it or?
He didn't overrule. He just stated do you want to proceed with your case over and over again.
He said what?
Do you want to proceed with your case? Do you want us to hear your case? That's what he kept on saying.
Oh, really? Okay. Well, that's taking it back to the public when he says that. That's an offer. Okay. So I'm trying to figure out what happened there. I don't understand. So he, what? This is the Comcast bill thing. They were suing you for a Comcast bill.
Oh, here's what happened. Comcast. I'll give you a backstory. Comcast. Years ago, I had to make it short. I had the service, discontinued the service, returned all the equipment, asked them, do I owe you anything? They said no. Call back a month later, do I owe you anything? They said no. I go to get a phone, they do a credit check and whatnot, and lo and behold, there's a collection on my account. No one did anything. No one sent me any bills, nothing like that. So I immediately challenged it, do a debt validation request, and also FICRA violations. They immediately removed it. Another year later, they do the same thing again. I do the same challenge to remove it. 2 years, 2017 comes around, they make up a phony account. They pull a Wells Fargo on me. Use my social security number without my authority, create a phony account to try and collect this money.
Oh, man.
Yeah, so now we have a problem.
Yeah, you got some Federal Debt Collection Practices Act violations you could take to federal court probably.
Okay, yeah, but I had, my father passed away, and I was trying to handle his affairs.
Yeah, so you pick your battles. I get it.
Yes. So I had an attorney, joke there, to try and handle the matter. He comes back and says the best he could do is, what was it he said, like $1,800? I'm like, are you nuts? They stole my credit. They stole my identity. They created a false bill. They did so many violations of the FICRA Act and FDCP that it's incredible. So anyhow, spoke to the attorney, and I fired him, and I spoke directly to Comcast attorney, and they agreed to go up, not a lot, but like $3,600. So I'm like, okay, whatever, just get beside the matter. I got things to do. So now they kept on demanding that I give them my Social Security number. Now, had it not been for your site and what I found out on there, that you cannot compel someone to disclose their Social Security number. Mm-hmm. This is what I started going after them on, and that's why I did the subrogation to, and I listed that.
No, wait, hang on, pause right there. You tell me something important, though. Okay, sure. I don't care about giving up Social Security numbers technically if it serves a purpose.
Okay.
They made you an offer, and you turned it down because you wouldn't give them a Social Security number?
Yeah, because the fact of the matter is how they want to use it. The way they stated it, they want to use it whenever matter they can. That's really what they wrote in the document. So I'm like, I'm not.
No, if it was conditioned, but I'm saying if it was a clear settlement and saying in order to pay you, which they don't need it to pay you. I'm just saying, but for credit reporting purposes, they have to have it.
Oh,
so, you'd have to say, what's the purpose of that? I need to know what you intend on using it for. If we're getting a clear settlement, why do you need a Social Security number? Just asking, and then maybe we can work that out. Are you making me an unconditional offer? And are you going to clear up my credit? Is that why you need it? Then, because sometimes it's a verification process too, because you probably used it to get the account.
Well, that was like I said, it was a long time ago, but it
doesn't matter.
They said it was, okay. But my driver's license would serve the same purpose. I mean, it was the same driver's license I used with my information on
But they
there.
probably took your Social Security number when you got the account so they could run credit.
Correct.
Okay, so see, I'm asking. I caught that because I'm trying to get you to understand. Sometimes you already gave it to them, so what are you fighting for? If it's going to get you a settlement, what do you care? It's just a tool you use. It's just a tool you use. If somebody's there's some other obscure reason not to give it to them, but if they're offering you a settlement, and it's just to get the account settled. Okay, I'll give it to you so long as there's conditional acceptance, so long as it's only being used to help settle this account. Is that what we're doing here?
Okay.
Get it in writing.
Yeah, good. Yeah, get it right. Because they said they need a W-9. They didn't need me to do a W-9s for their accounting purposes to file their taxes.
Okay, and that's, you know what? Let them take the tax deduction. If it gets you wanting the thing's over, you take it. I don't know if it's too late to just call them and say, look, I made a mistake there. I'll go ahead and give this to you to get this thing settled.
No, it's still because once the case was, because it went to arbitration. And it's in the arbitrator, because once the case got dismissed now, the arbitrator put it back into abeyance. So then I had the case dismissed, 4-1, Case is dismissed, so now I went back to arbitration again. And arbitrators right now doing review of the documents, the court documents, to see if it's the same matter or not, in both in arbitration and what happened in the court case. So,
well, I mean, it sounds like you need to just, you're taking this a little far for something as small as this.
Yeah, I was just concerned because
pick your battles, but you got that close to a settlement and you didn't take it, then you didn't turn the other cheek and just take a little bit and just get it over with. You made it worse, like it says in Matthew 25. See, I always tell people, here's my favorite saying: pigs get fed and hogs get slaughtered. It's okay to be a pig.
Yeah, I don't want to be a pig at all. No, got you, hog. Yeah,
you got to give a little bit to get a little, and then But granted, that sounds like they totally screwed up, and that's right. It's okay to fight for that, but you get to the point where they actually give you something you can work with. It's maybe not everything you wanted, but pigs get fed and hogs get slaughtered. Get it over with if you can.
Okay.
Sometimes you got to take it and get out and go back to your life.
Understood. Yeah. And as far as I'll ask you what I'll do too, because they wrote up the terms for the settlement, and they had so much legalese in there, it wasn't even funny, like 9 pages of legalese. So I think this time I'll just have the arbitrator do the settlement, or do you guys actually have a settlement document that I can utilize?
No, because it would have to be written for that specific scenario.
Okay. No template type device.
You can't template everything,
Understood.
You might wear a size 9 and somebody else wears 9.5, and sometimes you'll have a 9.5 on one foot and 9 on the other. All kinds of circumstances we can't anticipate, but it's the principle is the same. If they write you an arbitration agreement, then you want to have it reviewed by an attorney if you want to spend the money on that, or if you look at it and say, look, as long as I'm getting 2 things, I'm getting my money, and they're going to clear up my credit and leave me alone, 3 things. If that's what it says, get over it.
Okay. All right. Okay. Listen. Thanks again. So I won't even pursue the bill for damages or anything like that. Leave that alone. Just take what I have to take, and move on from there. Yeah, I definitely don't want to get started. You can if you want to,
but just remember that sound of what a gravy-sucking pig sounds like when it's dying. It's drowning in mud, and it's trying to get more before it dies, or it could have just got fed and go about its day.
Yeah.
Okay.
Great advice. Thank you so much, and thank you for all you do.
You bet.
Keep up the great work.
Okay. Bye-bye.
Take care. Enjoy your day. Bye-bye.
All right. Last callers, because we're out of time. Is area code 302. Quick question, please. 302.
Hey, TJ. On the previous caller, one of the things he could have done with his Social Security number is ask them to fill out a Form 56. Taking fiduciary responsibility, and fill in a W-9. And then he's agreeing with them, but I'm agreeing on you on the condition that you become my fiduciary and fill out a W-9.
Yeah. He said something about a W-9 in that. Maybe they were actually trying to get him to give him one. I'm not sure. That was unclear. But that's a good point. Certainly, obviously, appointment of fiduciary is a very good thing to do. Absolutely, because at least you know that they're going to take a tax benefit for giving you that money.
Exactly.
And they're going to, you don't want to be getting charged for that, because if you give them that, if you give them a W-9, they're actually going to charge you for their write-off. And then go take the tax credit. You got to be careful about that too. And they owe you money. You're not making money. You're taking back damages. So, but like I said, you weigh all these things and decide if it's something you can live with, whatever it is.
My experience when you ask them to fill out a Form 56 and a W-9, they back off immediately.
Yeah.
They don't want to do that.
Well, I hope he heard that. That's a good piece of advice for sure.
The question I had though was around property tax, and I live in Pennsylvania, and in Pennsylvania we don't have a consolidated property tax bill. It comes in from the township, from the school, and then from the county. So we end up with 3 bills.
Oh, great!
And I've been buried in administrative processes trying to get this thing settled. So the first one I got through using a bunch of arguments from a guy named Steve in Orlando. You probably know of him.
Mm-hmm.
And the second one I went through. I just got through it with all three taxing authorities using Title 31, Section 3124, which you're probably aware of, and Title 18, Section 8.
Yep.
Basically, and some of the folks on the call right now ought to write those two down: Title 31, Section 3124, and Title 18, Section 8, because they apply to traffic tickets as well.
Yeah.
And what 3124 says is stocks and obligations of the United States government are exempt from taxation by a state or political subdivision of the state. So it's saying that anyone that's using Federal Reserve notes as a payment is exempt from taxation. And what I did was I went to the head of each of the taxing authorities and asked them for the name of their counsel, so I could get their attorney, so I could get a legal determination on the species of payment that they were requiring me to pay. And of course, they all flipped out. You know, they didn't want to do it.
Say what? Yeah, I know. They get a little strange on that one.
So I got a lot of pushback. One guy was even very aggressive against me. He actually called the three local cops in our area, the police chief in one of our townships, the head of the highway patrol, and so it was hilarious. Because
but you were being peaceful and just asking, right?
Yeah, I was just asking. I mean, I said, you know, I wrote them all back, and I said, this guy's trying to be a drama queen. I'm just asking them what species of payment they'll accept for the pay. And and I think your listeners ought to realize if you go to the world currencies, you'll find that there's 30 plus currencies that use the dollar sign.
Mm-hmm. So I'll pay in pesos every time, man.
Yeah, or Jamaican dollars are even better.
Yeah, that's true. But I can get pesos though, right? I can go down and easily get pesos. Jamaicans probably too. Go to the airport and pick them up.
Colombian dollars are 3,124 to 1.
Yeah. So here you go.
And they use the dollar sign. So, well, anyway, I was listening to Anna Van Wright the other day, and she said that that what you can do is write your property tax assessor, I guess whoever does the assessment, whoever controls the property tax for the county, and tell them that there's been a mistake, that my property's been misidentified as real estate when it's actually private property. And I was just wondering if you knew anything about that approach and have anything on your website that you could point me to that would help me with that.
I'm only familiar with the argument. I haven't really put anything together based upon it like that. It does make sense from getting into a technical minutia standpoint of what's real estate, what's property. You know, for example, your house they always use a legal description, but that's not a location. And you know, location is a place on Earth. A legal description is someplace on a fictitious map that they control. Things like that matter. I mean, words absolutely do matter in all these different contexts, and but certainly those are valid things to look up. You know, when people are charging you for child support, for example, that's a very specific legal meaning. It has nothing to do with your kids. It's a legal contract that comes under the marriage contract, and that child is a piece of the estate that you signed in conjunction with the state when you put their name at the top of your marriage certificate. They became a co-trustee. And that includes all property derived from that estate that they have some control over. So when they come after child support, they're putting it into a legal category that they control instead of my property. Everything's your property. Your house, your land is your property. Your creations are your property. Your money that you hold is your property. You earned it. You know, you paid for it. Your kids are your property. They're your creation. They aren't children. child is we also understand the concept of operating under the fiction dead things, right? Everything is a fictional dead entity. Well, what is something that's cold? It's chilled. Child.
Okay.
See, that little things like that start to add. So there's not like one thing. I mean, you have to start looking at words differently. When we start syntaxing and parsing words, we really take it apart. But it is a similar. So when you use terms and words like legal, lawful, they all have different meanings. These are specifically, like if a normal person looked at 18 U.S.C. 8 and then 31 U.S.C. 3124, they might look at that and not think a thing about it. What does this have to do with me? When you realize that everything there has to do with you.
It does.
We're the creditors to the bank.
Yep.
These rules do apply. I had an attorney argue with me like the UCC has nothing to do with you. It has to do with they would sort of make this really weird argument. I said, that doesn't even make sense what you just said. Of course, why would it exist if it didn't? If it wasn't for me, if I wasn't here, there would be no banking system, and there would be no country running as a bank. And there was a movie. There was a movie. It was it came out a couple of years ago, and on the last line of the movie, I remember the actor Ed Harris. I can't remember the name of the movie, but he says, "Oh, what do rights mean anymore? We're just nothing but one big bank anymore." And he was saying in that movie, and I said, that's exactly right. We're just one big bank. We are just one big bank. We don't know what our relationship is to all of it. And when we don't know how to act accordingly, it hurts us. And you're right about 18 U.S.C. 8. I got them up on screen. I actually pull up a document we've got in the Start Here folder, which talks about an offer to settle. This is one way to approach a conditional acceptance of a bill or a crime or a charge. Don't they charge you when there's a crime?
Yep.
That's a bill. When they give you with the grand jury, what does a grand jury put out when they decide to indict you?
A true bill.
A true bill. Very interesting. Do you think these words don't mean anything? They mean everything. And what you just said about property and about property tax versus whatever it is they're doing. My point is, you've got to look at the different variances of these words and say, wait a minute, this does matter. The whole we thought it was about the bill, when really it was about the word property. They get you distracted so quick you don't even see what's coming.
Yeah. So in Michigan, when we were settling my father's estate, we were selling the house, and there's a transfer tax in Michigan. And when we were working with the title company, I asked her to bring up. There's an exemption in Michigan for anything that violates federal law. So I brought up 31 U.S. Section 3124 and Title 18, Section 8, and she says, "Wow, where'd you get this?" She was totally surprised. She had never seen it before. And she brought it in. They went through closing and transfer tax, but then after closing, they reimbursed it. So,
really? See?
Yeah.
There you go. That's a huge victory. See, and sometimes leaving at closing, you thought you were losing the deal, but by holding on to it, you realize that they look at this and go, "We got a liability now," And so, in fact, I had a situation with a transfer of an automobile in Washington State. It's pretty high sales tax. Fortunately, we don't have much other tax, just sales tax, no income tax, which I like. And, I was putting in the exemption for the sales tax when I transferred the title. And the guy, basically, we got through the whole process. The guy says, "Look," he says, "what you need to do," he says, "I can't deal with this now. I can only go up to this line. I have to collect it to do this. But here's a form you could submit for a refund." Okay, I'm just telling you, there's always a way. If you just ask right and you behave right, you're not threatening, and you stay on point, sometimes you get what you want. So, and it might happen also, and you think, well, after the fact, it is going to be harder, but sometimes they actually give you a remedy. They have to, technically. They can't steal from us. They can only get you to volunteer for it.
That may be the remedy, is to go ahead and pay the tax and then submit
Yeah, you
submit a request.
You put it under submit the tax under protest. See the exhibit. See, I got this exhibit up on screen. You might want to borrow this and use some of it in your submission as an exhibit that I expect to receive a refund afterwards. But in good faith, I'm putting this in, and then you have, if they accept it, you have a contract. Does that make sense?
Oh, that's cool. That's cool. Yeah, I like that.
But so submit it. I conditionally accept to pay this upon proof of claim that it's due, and if you don't provide me proof that it is in accordance with 18 U.S.C. 31 U.S.C. 3124, then I will expect a refund within 30 days if you don't otherwise prove it. You just wrote a contract. You just negotiated the deal based upon the law, and if they don't rebut it, now you got grounds for doing something.
Cool. What's the title of the document you're looking
at? It's Offer to Pay Debt. It's in our Start Here folder. It's the main first folder you get to in our folders on the website.
Okay.
And, yeah, that's the document. And, you know, I put it like high priority in there that this could be used for a lot of situations. Just kind of have to tweak it a little bit. And maybe you do go ahead and pay. You know, I'm going to submit this payment with the condition that if you take it, you accept and agree that I'm authorized to get a refund under 18 U.S.C. 8, 31 U.S.C. 3124. Now you're not in a controversy anymore with them, but the advantage is it's to you because you've got a contract. Because their silence will be their agreement.
I like that.
That's the rules. I'm just telling you the rules.
You also say that I'm paying in U.S. dollars as opposed to their presumption. I mean, they if I look at the county tax, there's no dollar sign on there. It's just a number.
Yeah, that's right. They don't put a dollar. That's common all across the country. They leave it blank. It's just a number. Okay, we'll write that number on a piece of paper and a promissory note and give it to them then. Didn't say it had to be anything but that.
Yep, that's true.
True. I know guys that do promissory notes and they just stick to the law and they use something like this as part of their attachment and say, well, you said they didn't put what species of dollar. You just said, you know, put this number down. Well, here's that number on a promissory note. And if you can tell me I have to pay some other way, then great, tell me. Otherwise, we'll consider this a settled agreement within 30 days.
That's cool. I like that idea.
It's just logical. It's the law. It's in accordance with the law. They wrote these rules, guys. We just don't know how to read. You went to that public fool system, and they taught you how to read, didn't they?
Yep.
You know.
And one other question regarding the deed. I'm going through the word process or word power videos, and you put on copy names on a number of different documents, and I was just wondering if doing that on the deed would have any effect.
Sure. What if they copy it after you submit that to them? Then they agree that it's to violate a copyright, private copyright, which is superior law to any public law, according to the Constitution. I think it's Article 1, Section 8, I forget which one it is, but it talks about no law should be written that supersedes the Constitution, basically. I don't have it off the top of my head. But that's a private contract now. That's why we can copyright our own documents. And it's superior law.
And you said in one of the videos that they cannot bring forth a countervailing claim because they don't have the authority to do that, or they don't have the power to do that, being fictions?
Basically, I'm trying to get the context of that, but yeah, that's essentially the rules.
Yeah, I might try to do that too, and send that to the assessor and say take it off the property tax rolls.
Yeah, so because it's use the proper term. It's not property. It's, I forget the right term. It's not real estate. It's my personal property or something like that. I don't know how she phrased it. I've heard her argument on that. It's pretty interesting. Just tell them, it's private property. It's not real estate by your definition, unless you can prove otherwise. You may do it always as a conditional offer.
Yep,
you always get further by putting, because then you give them an opportunity to respond. They fail to respond, therefore they agree. And that's just the way it works. It's how the IRS gets you into a contract. They send you enough documents, and eventually you just sit there scared and shaking, and then next thing they go, well, I guess we can presume that this lien's good. And it's pretty hard to beat after that.
Yep. It's good. Good points. Thank you.
I know. I hate to tell you that I learned a lot of this the hard way.
I'm learning too.
I'm stubborn and stupid too. You know, I'm no saint. I'm just trying to share what I've seen and heard and experienced and heard from others. You know, firsthand knowledge. Okay.
Yep. Appreciate it. Thank you.
All right, so I have it up on screen, guys, in case you want to see that document. But it's in the Start Here folder. You should use it. Variations of it. You might need to tweak it a little bit. I mean, it's just an idea that you start with and you apply it to your situation. But it's always a conditional offer. You know, it's not a threat. It's not an argument. But you do give them a deadline, and if they don't respond, then you can assume nothing further is owed, and the matter's resolved. And then after that, you now have set up your court. You set up your claim. You've done it. Okay?
That's perfect. I love it.
Yeah. That's how everything works. You look at how courts operate. They'll say, did you exhaust administrative remedies? What do they mean? I mean, did you give everybody a chance to work it out? Biblical law. Do that first, and it'll work in your favor. Okay?
Yeah, there's actually, when you do an administrative process that they don't answer, there's not a controversy, right? They've already admitted.
If that's what the terms of the agreement said, and you gave them notice and opportunity, and you gave them a follow-up usually, sometimes you send a follow-up to this, say, hey, looks like 10 days have expired. I'll give you one more chance, otherwise, you know, we'll assume this thing is in effect, you know, with a copy of what you previously sent. That's all administrative process is. People are like, give me the template. No, just use a little common sense. You send them a notice, you give them a second opportunity, then you let them know they've defaulted. That's it. Legally speaking, you can go to court without that, but you're far stronger if you can go to court with that. Because it's all right. Court. It's all court. You're holding court right now. You're building your record.
Have people taken a 3-step administrative process to a small claims court?
Well, you can take anything to small claims court. If you have a 3-step administrative process, you now have some evidence, don't you?
Yeah.
Rather than, well, she, you know, took my bicycle and didn't have it right, and you sound like a debtor sitting there arguing. And I say, Your Honor, I'm here to settle this matter. I've already settled it, in fact. There's no need for this proceeding to go any further. It's already a settled matter. I'm just here to collect my bill, sir. Here's the proof. See, that's a creditor.
Yep.
So the debtor, you watch those people on TV, man, you're like, oh my gosh, listen to those people whine and argue and bitch. And they don't get it. And then the judge has to beat them up. It's his job. It's the judge's job to see these children be misbehaving, to treat them as such.
Yep.
And don't we do that too often?
Too often.
Yeah. You know, it's in the Bible. I don't remember where it talks about this. It talks about, though, treating, I think it's in Paul, talking about, you know, they're a bit like children. That's what he's talking about. He's talking about it's the way we behave. But we're kings. We're God's children. For crying out loud, this earth that we're supposed to take dominion over. It's all out of the Bible, guys. It's the rules of law and order. It works for us, but it works against us if we play stupid. So, you know, be a creditor. That's my theme. I'm going to try to remind you guys this for a while. Be a creditor, then these remedies will all come to you. Even if you're as guilty as sin, be a creditor. Accept responsibility and work it out.
Yep.
Because if you got yourself into something, you know, TJ's not going to give you the magic words to get you out. But you might get off for less.
No, I'm just trying to get separated from all these criminal enterprises that the government's put together to soak us all.
Well, and listen, I tend to agree with you, but I also tend to disagree with what you just said. What if they're doing their job? Well, and we're not doing our job. We haven't informed them of the proper status and arrangement. We haven't given them the remedy, so they can only do it one way because they have a job to do it that way.
I agree with you to a certain degree, but when you have this booklet that you suggested we read, this universal something technology.
Oh, yeah.
And it got to the point where it talked about the golden rule. Remember that?
Mm-hmm. Okay.
Where the judge can interpret anything that's said in the court any way he wants.
Judicial discretion is called. Those are the words they use.
Yeah, they in this document though
they leave just enough vague language in their laws for judicial discretion. They do it intentionally.
Yep. So they can interpret anything you say. You know, like I remember this.
Anything you say and do can be used against you. That doesn't even matter if it makes sense or not. Anything.
Yeah, if you say I do not consent, they can interpret it as I could be AYE, which is yes. Do is not DO, it's DUE, so you owe something.
That's why we like we like to ask them to communicate in the correct sentence structure, syntax, parser, grammar, now time, language with the proper name, so that we're all on the same page.
Right.
That's the magic of the syntaxing technology of plugging that in. But sometimes it doesn't even take that. It just takes a conditional acceptance offer. You know, I mean, truthfully, you could write this same thing, just turn it around and put it in actually now time language and it'd be even stronger. But you have to talk to them at their level, too.
Yep.
But how you act is the key. So, anyway, you're on the right track. Okay?
Okay. Thanks for your help. Appreciate it.
You bet. So, folks, that's all I got. Let's see, is anybody else in there? I don't think I got him. That's him done with him. So we're done with everybody in the queue. We're done with this webinar. I will get this posted up the website tonight. I probably will not be having an event next Tuesday. I'm traveling to see my new grandson who just was born. I need to go see him. And that's going to take me offline for several days, so don't expect a lot of responses to miscellaneous questions. Try to keep it to a small roar. Use the forum and talk to each other, though, as much as you can. You can also talk to each other in the Telegram group. So just be sure you do that sort of thing. But I appreciate everybody. Somebody says they can't see screen. I don't know. I thought I unpaused it already. Okay. Anyway. That's strange. I thought I did unpause it. No, it says it's showing. Let's see here. Anyway, it's the document that's the offer to pay. Just look that up. Anyway, I'll see you all next time.